Kenya celebrated its Jamhuri Day, its 60th Jamhuri Day on the 12th of December to celebrate the independence that we got on the 12th of December 1963. We were given a constitution in 1963 that was mutilated, and public servants were protected under that constitution. Later that constitution was mutilated, and in 1969 the public servants now started to serve at the pleasure of the president. Kenyans in coming to 2010 enacted a new constitution that completely made public servants insulated from the arbitrary actions of the executive. In that constitution, there were created independent officers and constitutional officers. This is a creature that the Kenyans created to protect the occupants of that office, that they must have a tenure specific for 8 years or for 4 years. The control of budget enjoys that constitutional immunity within the provisions of the Constitution. What has happened? The state, being annoyed with the manner in which the control of budget has exposed a rotten government, designed a way to remove her from office. First, a charge sheet purporting that the control of budget was a director of a SACCO. We rushed to court, provided evidence that she was never elected as a director of that SACCO. And therefore that was a move that was calculated to ensure that the reasons provided for removal of Nyakong'o under Article 251 is that once she's charged, they'll go to Parliament, file a petition, take it to the President will appoint a tribunal, the tribunal, meanwhile the control of budget will be suspended, and once the tribunal that is appointed by the executive delivers the decision, just like the Cherera, the Nyakong'o's fate will have been sealed. Went to court, and that matter was stopped. The real issue today that we are here is our petition is premised on two issues. One, can a constitutional office bearer be charged in a criminal court before she's removed officially from that office? We provided to the court authorities where 5 judges sat when the Deputy Chief Justice they tried to arraign her to court. And the courts sat and provided a judgment of 5 judges. And among the judges' recommendations, which is the law of this country, you can never take a constitutional office holder in the discharge of a mandate as a control of budget through a criminal process until you have removed her by a legal mechanisms provided for under Article 251. This was the position that the DPP, the DCI faced the Waterloo when they were told that Deputy Chief Justice will go to JSC, get her removed from being a judge, then arraign her in court. We invoked the same provisions, and the judges agreed with us that you cannot take a constitutional office holder. They have temporal immunity the same way the President of the Republic of Kenya has permanent immunity. Constitutional office holders have temporal immunity against criminal sanctions until they have been removed from office. The judges agreed with us and stopped charging arresting, arraigning, persecuting one Nyakong'o from office. The second question that we raised before the judges is the manner in which senior constitutional office holders are being dealt with. And this might be a testing ground for many of the constitutional office holders to be hounded of office. We know there are more than 11 to 13 constitutional officers with around 3 to 9 constitutional office holders. We know judges of the court of the High Court, judges of the Court of Appeal, judges of the Supreme Court enjoy that immunity. We know the director of public prosecution can also not be removed or cannot be charged unless Article 158 is invoked. In summary, today we have come before the Supreme Court. Only the petition for presidential election is covered by media from this place. We have come to the nakedness of the justice system. We have come to the seat of the name Supreme. There are only two Supremes. One, the Supreme Court, and two, the Supreme Law, which is the Constitution. It is historic. It is fundamental. It is a landmark ruling by the judge that the Constitution is supreme. Any act contrary to the Constitution, as provided for in Article 2, is null and void. So the act of the DPP, the act of the EFCC, the act of the executive wanting to charge Nyakong'o has been declared unconstitutional against the tenets of the supremacy of the law that governs this country, because this Supreme Court and this Supreme Law is the law that was enacted by 55 million Kenyans. It was not enacted by 349 members of parliament. It's a big win and we celebrate that. Kwa wale ambao kidogo lugha